Hey, I'm Hannah Hill, Vice President of the National Foundation for Gun Rights, joined by the one and only William Kirk from Washington Gun Law. Welcome.
Thank you so much for having me here. It's great to be out here.
We're so tickled to have y'all in the office today.
I appreciate it. Thank you so much.
So we wanted to sit down and go over with y'all the next assault weapons ban case before the Supreme Court.
The next one. That's
the
right.
next one.
That's right. in a long line of them.
Because we literally just finished bringing them one, and they said, no, not yet. Well, the next one is up.
It is.
Before the Supreme Court.
It is.
And we have a lot of hope that this will be the one that they agree to take.
Well, and you know, Hannah, we're talking about the Snope case. A lot of people may know it as the Bianchi v. Brown case, but they've replaced the name plaintiff in that. Same issue, same case. And what the court had always said is that they didn't like a case in an interlocutory fashion, right? That it was, we were trying to appeal it in the third quarter of the ball game, and they wanted to see the clock read zeros before they took the appeal. Well, this case is exactly situated exactly the way the Supreme Court wants it.
Like, bring us one on the merits. Well, this is on the merits.
This is it.
Yep. And this has a lot of interesting history because this was one of the handful of cases that was pending at the same time Bruen was pending.
Yeah, you know, and you brought that to my attention, and I was like, oh my gosh, that's right. And so this case was GVR'd back down to the court in June of 2022.
So for the non-lawyers, tell us what GVR means.
GVR means grant, vacate, and review. And what happens is the Supreme Court will issue a ruling, and it has other petitions pending that now may have been answered by that court's ruling. So what they will do is they will grant review, they will vacate the ruling of the lower court, and then they will remand it back to the lower court with instructions to, hey, do over and read this opinion and see if it changes your mind, which we assumed was going to happen when the Bruen opinion first came out, and yet here we are 2.5 years later still talking about it.
So, and that wasn't the only one, the only assault weapons ban case that was pending at the time. You had this one in the Fourth Circuit. You had Duncan out of the Ninth Circuit.
Yeah, Miller. It was actually the Miller case.
Miller
v. Bonta went back to the Ninth Circuit. Judge down there, of course, ruled once again in favor of the plaintiffs, and then the Ninth Circuit swooped in, sucked it up, and never to be heard from again.
Right.
So we still don't know what's going on with the Miller case. They did the same thing with Duncan, too, which was a magazine ban case that was GVR'd at the exact same time that this Maryland case was GVR'd also. So.
Right. So while we're waiting for those two cases out of the Ninth Circuit, all of a sudden, Bianchi, I've never been sure how that's pronounced.
Bianchi, yeah.
Bianchi. That suddenly started moving after some really pretty crazy process shenanigans on the part of the
Yeah, it was kind of a horse race. We were analyzing to see who would end up with pole position, and we really figured it would probably either be one of those that came out of the Ninth Circuit, or the way things had accelerated so rapidly in Illinois.
Right.
That we thought that there could be a case out of the Seventh Circuit coming.
A little painful for us.
Very painful for the folks in Illinois.
Right.
But then in the last couple of months, you're absolutely right. There was just a lot of activity on this Maryland case. And next thing you know, about 60 days ago, we were all saying, hey, this one's kind of in pole position now.
Right.
It's got the inside track. Right. It's complete. So there really is nothing else that any other court could ever do to this case, so it is ripe for review by the United States Supreme Court.
No lower court box left unchecked, and that's really what Justice Thomas said. So in the Naperville case out of Illinois that we brought to the Supreme Court, we were on that interlocutory position there. We were asking for a preliminary injunction. Suspend the enforcement of this new law, and if they had weighed in and done that, that essentially would have given case law for the lower courts to strike the case down, strike the law down once and for all. But they didn't do that.
Right.
But Justice Thomas gave us a statement, kind of giving some background into their thought process. You know, this is interlocutory, it's not ripe for review, bring it back on the merits. If they say the same thing, if they say that ARs aren't guns, and that sort of absolute nonsense.
Intellectually dishonest way of upholding the law, yes.
Then the Supreme Court, he said, can and should take the case.
Yes.
Well,
here we go.
Here we go.
It's exactly what he asked for. And I think that I'm hopeful, at least, Hannah, that the Supreme Court is also going to see how their authority has been flouted.
Right.
That these lower courts have essentially been thumbing the nose at the rule of law as announced by the United States Supreme Court. We have a Seventh Circuit there in Illinois that's ruled that the Second Amendment doesn't even apply to semi-automatic rifles. So think about that. They are now ruling that the most common long gun in circulation in the United States is actually not protected by the Second Amendment. The Fourth Circuit that you're appealing from here didn't come up with as crazy of a ruling, but it still just reeks with all sorts of intellectual dishonesty. And it really does fly in the face of Supreme Court precedent. So I'm hopeful that the justices are just going to put their foot down now.
Me too. And while this is not our case exactly, we just filed an amicus brief pointing that out to the Supreme Court and saying, okay, it's time. This is what you wanted. It is time to take this. But we did something that we've not done before in a case, and this is we expanded it from the right to self-defense against private violence to the right to self-defense against public violence. Remember why the founders put the Second Amendment in there to begin with, and remember where they were coming from.
That's right.
Just off of a war with the greatest military power on the face of the earth.
That's right. And if you go back and you take a look at some of the older cases, like United States v. Miller, which is a case that actually the common use test really grows from, the problem with the court had with the ban on the short barrel shotgun is that they believed that a short barrel shotgun was not appropriate for military use.
Right.
Well, if that's the way their line of thinking, then anything that is appropriate for military use would be protected, which means Americans would certainly be entitled to semi-automatic rifles and arguably entitled to even more than that.
Exactly. And you want history and tradition? Well, what would the founding fathers have been carrying at the Battle of Lexington if it happened today?
Well, and if you look at history and tradition, what did local militias expect and require of their members? They actually expected them to come with weapons that were designed for modern warfare at that time.
In common use to fight wars with, because that's literally what the militia was there for. Yes, it was an individual right, but there were also expectations with that.
That's right.
And it was there to protect not only from private violence, which is your break-ins and your home invasions and criminal attacks, but also public violence. And so what did they mean by public violence? That's the part that the courts have been very conveniently overlooking.
Well, not like we've had a problem with public violence in the last few years in the United States. So at least we don't have any real life examples
to pull from
of society completely breaking down into a state of anarchy.
Mm-hmm. Or any tyranny that's a little bit disturbing.
Not like the pandemic showed any levels of tyranny or government overreach or anything like that.
Or riots or anything where, law enforcement is just saying, you know what, we're not going to get involved. We're going to let anarchy reign in the streets.
Well, listen, I want to commend the NAGR because a lot of people don't realize that when you're doing an amicus brief, you're not just writing a 25-page brief that says ditto, just exactly what that guy said. In fact, really good amicus briefs will take a look at what the issues that have been argued already and say, okay, they couldn't get all of these other issues in their page limit, so we're going to pick up some of it, and we're going to talk about this issue over here, which is one of the things you guys did as far as talking about what is the purpose of arming Americans. And that was a subject that I'm sure the lead plaintiffs wanted to cover, but again, you have very strict page limits, and the Supreme Court doesn't fuss around with their page limits. So it's great to see amicus parties come in and write something that is creative and not just yeah, me too. So kudos to NAGR and to the people who drafted the brief. It's very well written, and everyone should kind of geek out on it.
Well, and I'll tell you kind of where Barry Arrington, our chief legal counsel, got that idea. It actually came from the Rahimi ruling not long ago. So he's reading that, and Justice Roberts in that ruling points out some histories like, this is not only about the Second Amendment for self-defense, it's also came after the founding fathers were fighting at the Battle of Lexington. It's also important to help, in the days following the Civil War.
Sure, the historical context in which we then announce those rights, they can't be ignored.
No, they can't. But when you do that, both of those instances, the American Revolution was about public violence coming from government. The days following the Civil War, public violence coming from mobs, in the Reconstruction era South. So, and the right to self-defense is important for both of those, and Heller emphasized that as well. It's just that the courts have very, very conveniently overlooked that side of it, which falls apart, when you say, actually, no, this is a part of self-defense too.
Yeah.
And that is why militaristic weapons is not... is indeed, in fact, covered under the Second Amendment, no matter what these lower courts are saying.
It is. And I think the other important thing is that even though in the summer of 2022, people like you and me all thought that the Bruen opinion was very clear.
And we did.
And I still read it, and I think it's very clear. Apparently, a lot of the lower courts didn't get that memo. And so they have been struggling with it mightily. And with all due respect to Chief Justice Roberts, I don't think he did us any favors in the language he chose to use in Rahimi. I'm not really dismayed by the outcome, but there is a tremendous amount of sloppy language in there that is going to be used to further civilian disarmament. And so the acceptance by the Supreme Court of this case out of Maryland is a wonderful opportunity for the Supreme Court to really tighten that language up so there's no more guessing, because those that are guessing are oftentimes guessing wrong.
Well, and it's not just guessing wrong either, but back to your earlier point, a lot of it's actually bad faith. There's no way that a judge can argue that ARs aren't guns under the Second Amendment, aren't protected under the Second Amendment, don't even qualify as arms under the Second Amendment. They can't argue that in good faith.
No, they can't. And they can't argue that they're not in common use.
No.
They'll come up with new rules of law like in common use for self-defense. I am still scouring the case law to find what case that rule of law comes from. And this is just one of the many, many tools that they're doing. And again, this is my criticism on the Rahimi case, is it gives them the language to have this wiggle room. So this case that we're talking about today is a great opportunity to really just box in that analysis once and for all.
And they're going to have to do it. Like if they want Bruen to be followed, they are going to have to ultimately step in and enforce it. And the only thing they've stepped in at this point is when the courts were too restrictive against the government's restricting of Second Amendment rights. That's basically what Rahimi is. I personally think the Fifth Circuit got that one right. But they don't come in and step in when the Seventh Circuit says, oh no, ARs aren't guns under the Second Amendment, you can ban assault weapons. And it's time, long past time, for them to start bringing some order to the courts on that one.
Well, I agree. And you know, this is the highest court in the land, and those that scream for civilian disarmament also spend a number of years screaming about the rule of law, the rule of law, the rule of law, and yet they don't want to seem to follow the rule of law. And if you think that the courts in Maryland or Illinois or California are crooked, read the opinions that come out of the state of Hawaii. Right? Because they're basically throwing a middle finger at the United States Supreme Court. And so I really just want to see the Supreme Court establish the authority that our founding fathers intended it to have.
Right. And actually say, you know what, the Second Amendment does in fact mean shall not be infringed. It does. It really isn't rocket science.
It's not.
And basically what we need is the will and the action from the Supreme Court to follow through with what they said in Bruen. And this case gives them the perfect vehicle to do that. Everything that they have asked for up till now in a gun ban case, this case has given them.
That's right.
And so we're going to wait.
Gift wrap with a big bow on
There
it,
you
just
go.
the way they want it.
So stay tuned for more updates on that. We will keep you posted on how this case goes and when we actually get a conference date for this case, and hopefully we'll be getting some good news out of the Supreme Court on that soon. So William,
listen, first of all, I want to thank everyone at NAGR for having me out here to Colorado. And for those of you who geek out on my channel, you know that I routinely talk about where should you be putting your money, okay? And where you should be putting your money is for the people that are willing and the organizations that are willing to get down in the trenches, to fight like crazy for your inalienable rights, to get their knuckles bloodied. And NAGR is one of those organizations that has done it time and time and time again. We're talking about just one in a long list of cases. So if you're looking for an organization that really wants to take the fight to those that are trying to take your rights, consider joining the National Association for Gun Rights today. And Hannah, thank you so much for having me here.
Thanks
It's been
so
a
much
pleasure.
for being here.
Yeah,
Finally
thank
good
you.
to meet you in person.
Likewise.